and prohibit from that date all transboundary movements of hazardous waste destined for recovery or recycling from OECD to non-OECD states. And at its next meeting in 1995, COP3, the Conference of the Parties adopted a further decision, which we refer to as Decision 3/1, whereby this was made into an amendment to the Convention text itself. Now, some of you may be aware that there were quite a lot of discussions since that date, which led to this decision that you have up on the screen in front of you, Decision BC 10-3, which addressed entry into force of the ban amendment. And by that decision, the Conference of the Parties agreed to an interpretation of the Article 17 of the Basel Convention, which talks about amendments. And there was an agreement on how to interpret the requirements for entry into force of an amendment. In addition, Section A of this Decision 10-3 invited parties to continue to take concrete actions towards encouraging and assisting parties to ratify the ban amendment. And there were specific suggestions made as to those concrete actions, which included specific actions to assist parties facing legal and technical difficulties in ratifying the ban amendment. There was reference as well to regional meetings, and there was reference to country-specific studies on what would be the implications of ratification and entry into force of the ban amendment. Now, we've just referred to Article 17 of the Basel Convention, which contains specific requirements for the procedures for entry into force of amendments. And that falls within the first bullet you see in front of you about requirements that are set out in the specific treaty. Now, for the Basel Convention, these requirements are set out in the latter part of the treaty. And you also have similar provisions within the Rotterdam and Stockholm Conventions explaining the steps that parties can take towards becoming a party and how they can express that they would like to be bound, they agree to be bound by the provisions of that convention. There are subsidiary or secondary rules that are contained within this Vienna Convention on the Law of Treaties. And so you have both general steps as well as convention-specific steps. Now, we've made mention to the need for a state or a relevant organization to express its consent to be bound by the treaty, or for that case by an amendment to a treaty. That is how the main step for how to become a party. There are general steps that are explained in the treaty handbook, and this has been prepared by the treaty section of the United Nations Office of Legal Affairs and is available in all 6 United Nations languages on the treaty section website. The convention-specific steps are very similar between the Basel, Rotterdam, and Stockholm Conventions. The convention specifies the instruments through which a state can express its consent to be bound. And in order to do so, it has to deposit its instrument of either ratification, approval, acceptance. There are specific possibilities that are left open to the state, and they prepare the relevant instrument and deposit that with the depository. The consent to be bound will only take effect once this instrument has been deposited with the depository of the convention, and that state then becomes a party or legally bound by the convention on the 90th day after the date when it deposits its instrument. Before depositing its instrument, however, there are certain steps, certain preparations that many states do undertake in order to decide whether or not they wish to be bound by the relevant convention or by the amendment. So firstly, you would have certain analyses carried out, collection of documentation. This could be, for example, looking at what the benefits and implications would be of becoming a party and balancing that with the associated costs. Secondly, there would be contact and consultations between the lead ministry, if you like to refer to them as that, and their government authority responsible for drafting instruments to become a party to international agreements. This is normally a legal unit within the Ministry of Foreign Affairs, but it depends on each national system and the institutional setup within that country. The responsible authority would identify who at the national level would take a decision on or approve the instrument to become a party to the convention or to consent to be bound by an amendment. This decision or approval would then provide the basis for issuing the relevant instrument, so the instrument of ratification, acceptance, approval, or accession. And then that must be signed by a person with the full powers to do so. The relevant processes at the national level that lead to endorsement of such ratification, acceptance, approval, or accession would then be identified and initiated. In doing so, the state would decide if any declarations or statements are needed, and it is important to do this at this stage because it may well be that those declarations and statements have to be incorporated within the relevant instrument. Once that decision, that determination is made, there needs to be the preparation and signature of the instrument. In the practice of many states, the authorities responsible for preparing the instrument will be the Ministry of Foreign Affairs. However, again, each state needs to look at its particular national circumstances and institutional setup. The instrument should also be signed by the head of state, head of government, or Ministry of Foreign Affairs, or another person possessing a valid instrument of full powers. After the instrument has been prepared and signed, it can then be deposited with the depository. So, a quick recap on what the steps are to deposit the instrument. You have to determine what type of instrument is needed, so whether the national circumstances call for ratification, for acceptance, for approval, who can execute the instrument. And here we're talking about the head of state, head of government, Minister of Foreign Affairs, or a person with full powers. And talking about the full powers, there are model instruments of full powers that countries can use as examples if that is a route that they wish to take. And those are available within the treaty handbook we referred to a couple of minutes ago. Is there a form or format for the instrument? There isn't a mandated form. It depends very much on the national legal and constitutional system. The instrument and any additional documentation or declarations required also depend on this national legal and constitutional system. However, there are 5 key elements that need to be incorporated within the instrument. Firstly, title, date, and place of conclusion of the treaty. So here would be, for example, the Basel Convention, the Rotterdam Convention, Stockholm Convention, or the Ban Amendment, for example. Secondly, the full name and title of the person signing the instrument. So here you would have the head of state, head of government, Minister of Foreign Affairs, or the other person authorized to do so. Thirdly, you'd have an unambiguous expression of the intent to consider the state bound by the convention and to undertake to observe and implement its provisions. Fourthly, you would then have the date and place where the instrument was issued, and lastly, the signature of the authorized person. So again, here we would be referring to the head of state, head of government, Minister of Foreign Affairs, or a person with full powers for that purpose. Now, should anyone be interested, there are also within the treaty handbook model instruments of ratification, acceptance or approval, model instrument of accession, model instruments of declaration, and as we mentioned before, model instruments of full powers. How to deliver? It's important to note, as we mentioned before, that the instrument is only effective once it's deposited with the depository. For all three of the conventions that we were referring to here, as well as any amendments or protocols thereto, the Secretary General of the United Nations is designated as the depository within the provisions of the conventions. Under Article 102 of the United Nations Charter, the treaty section of the United Nations Office of Legal Affairs acts as the depository on behalf of the Secretary General. It's recommended that the instrument is delivered directly to the treaty section to ensure that the action is promptly processed, and where feasible, that states provide courtesy translations in English and or in French of instruments which are in other languages. And this just facilitates the prompt processing of the action so that there's not an additional step of translation in between. Now, in terms of declarations, reservations, or exceptions, none of the three conventions to which we refer here allow for reservations or acceptance. But states can make what we refer to as an optional declaration. So this would be, for example, agreeing with respect of any party that accepts the same obligation to submit disputes to the International Court of Justice or arbitration in accordance with the provisions of the conventions. A state can also make an interpretive declaration. Again, just to reinforce that it is absolutely essential that the instrument is deposited with the depository directly so as to have a prompt processing of the action. And just to summarize those steps, you would have a lead authority designated in relation to the convention, or it could be the amendment or the protocol concerned. That authority would prepare analyses and collect documentation, as well as initiate consultations with the authority responsible for issuing the instrument. The relevant processes at the national level will be identified and initiated, and this would include determination of whether any declarations or statements are needed, and the instrument would be prepared and signed. And here, just to reiterate that you would need signature by either the Minister of Foreign Affairs, the head of state, or the head of government, following which the instrument is deposited with the depository, and 90 days after that date, it would enter into force. Now, for amendments, the steps are very similar. In order for an amendment to be adopted, there are certain general steps that we refer to. There has to be agreement between the parties as a first step. And within the process of coming to that agreement, any party to the convention, so whether that be the Basel Convention, the Rotterdam Convention, or the Stockholm Convention, any party to that particular convention is entitled to participate in negotiations of an amendment to that text. On entry into force, the amendment binds only those parties that have formally expressed their consent to be bound. States becoming parties after entry into force of the Convention become parties to the Convention as it's amended. There are, as we mentioned before, specific steps that are contained within each Convention, and should a party express when should a new party, when it becomes a party, state that it will not be bound by an amendment, then that party will not be bound by the amended Convention. Now, looking at the specific procedures to adopt an amendment to the Basel Convention, you would firstly have a party transmitting a proposal to the Secretariat of an amendment to the Convention, or there is also a protocol that has yet to enter into force. The Secretariat then communicates that proposal to all parties at least 6 months before the next meeting of the Conference of the Parties, and the proposal is discussed at that meeting, negotiated, and potentially adopted. After adoption of the amendment, the depository circulates a notification, after which parties may elect to consent to be bound and expresses its consent. And here we revert to the processes we were just describing about depositing instruments with, preparing and depositing instruments with the depository. The amendment will enter into force for that particular party after it deposits its instrument. However, as we just mentioned, new parties will be bound by the Convention as amended unless they specify otherwise when they become a party. So as you can see, there are similarities in the processes and procedures that are applicable to the conventions and to the amendments, but with specific differences between the procedures. There are tools and guidance to assist parties that wish to express their consent to be bound by amendments or protocols, or states that wish to become party to the convention. As mentioned, we have, for example, the treaty handbook that's available in six languages with models that are contained therein. We also have the convention's websites that are currently being updated and will soon have further information available on them. And so there is much support that is available for those parties that wish to take this step. Of course, it is a national decision, essentially, and it is the prerogative of the party concerned to decide whether or not it wishes to express its consent to be bound by a particular amendment or a state wishing to be bound by the treaty or convention in question. So there are certain steps at the national level, and then followed by the expression of consent at what you might refer to as the international level. And of course, the depository, guided by each convention's provisions, has the authority to decide when requirements for entry into force are met. For further information, please feel free to have a look at the websites for each convention, or the Secretariat is also available to assist as necessary. Now, that brings us to the end of our presentation, and I will turn over to Yun for the questions and answer session.